recommend beneficiary designation planning. There's an excellent seminar that's provided by a banking president here in Sheridan where he eviscerates that idea out of hand. The problem with it is that things change over time. And if you say, let's say that you put a joint tenancy with your son and you don't specify who owns what, and your son ends up in a bankruptcy situation, your son owns 50% of the property that you're on. That's not the situation that you want to be in. Or let's say that your son passes away and you forget to change the title on your house, or you forget to change the beneficiary designation on your IRA. That's not going to keep up. We're going to end up in probate, and they're going to be non-exempt assets at some point in time. I'll give a specific example. There was a case out of California a couple of years ago where a man had been married to the love of his life. She contracted cancer and died. He had a bounce-back relationship and married a Keno girl from Nevada somewhere. That relationship lasted about 6 months. They separated. They went their own separate ways. At a high school reunion some months later, he met an old high school sweetheart. They fell in love. They had a lovely relationship and remained married for 10 years. At the end of that 10 years, he passed away. The only asset really in the estate outside of the house was a $1.2 million IRA. The beneficiary designation under that IRA went to the Keno girl. He had mistakenly put her on there, or he put her on there, meant to do it, but he had not updated the beneficiary designation. So the descendants and the wife at the time that he passed away then initiated a suit to try to claw that back. And the court looked at them and said, no, the beneficiary designation holds. It's a dead man statute. You can't revise that. So the $1.2 million went to the Keno girl, who then subsequently did the right thing. She kept the money. The family ended up losing all of that under beneficiary designations. The problem is that if you take all of your assets and put it into a trust, that beneficiary designation does not change, so that if you want to change anything in that trust, you make minor revisions to the trust. You don't rely on beneficiary designations. It's single-handedly the worst method for planning for devise of an estate that exists today. If you give your money away and you don't put it into a Medicaid asset protection trust for your benefit, here's the risk. 90% of all gifts and inheritances are spent within 1 year of receipt, irrespective of the amount. And I'll give you an example. A couple of years ago, there was a guy in England who inherited about £1 million, which I have no idea what that is, probably $1.5 million at the time. He was employed, so he decided that what he wanted to do is that he wanted to take a roll on the roulette wheel, so he called up Binion's Horseshoe in Las Vegas, Nevada. He said, I want to come down, I want to put $1 million on the roll of the wheel, I want to get rid of one of the double odds, so I want to increase my odds somewhat. Binion's called out, laid out the bets, got everything put together, sent a jet over to the guy. The guy came with his girlfriend, his best friend, and his best friend's girlfriend. They stayed 2 nights at Binion's, ate, drank, had a great time, put their tuxedos on, went down to the roulette wheel, rolled it. Guess what happened? They lost. They lost everything, because everyone always loses everything. That's how they pay for that stuff. So there went that individual's $1.5 million inheritance in one roll of the roulette wheel that his parents had saved their entire life to provide for him. So that's what you do with inheritances. You might want to maintain some control over your money after you've passed away. A Medicaid asset protection trust is one way to do that.